we are going to talk about intellectual property rights. There are three words involved in intellectual property right. The first word is intellectual, which refers to one's mental faculty, okay, through which he has evolved upon some kinds of services or products. Since he is the creator of the services or the products, naturally it becomes his property, and there is a kind of ownership he can enjoy uh, on that particular product or services. And his ownership can be protected through certain kinds of laws and rules, okay, which are the part of his rights, okay. So normally when we talk about intellectual property rights, it is basically one can evolve certain kinds of products and services through which he is credited to, and through certain kinds of laws he can enjoy his ownership on that particular property. Basically, this is the part of human rights, Universal Declaration of Human Rights, Article 27. The second thing, this slide is basically about the definition of intellectual property rights. The first one, if you can see, it is basically the rights through legislations of owner responsibility for creating or owning an intellectual object. And the second definition says that it is empowerment of owner to enjoy the benefits or credit towards owning an intellectual object through the law of land. When we talk about the benefit and credit, benefit sometimes refers to commercial or economic, and through other means. However, when we talk about credit, okay, especially on literary works, it is many times it is not monetary, but one should get his credit, okay. So basically the owner enjoys the benefit or the credit of the work which he has done, and based on that particular work, if somebody evolves on some kind of new object and new kind of services, the owner must be given the due credit for that. This slide basically is the definition World Intellectual Property Organization, which is also called as WIPO, which has its head office at Geneva, Switzerland, has given, uh, which uh, uh, which is intellectual property normally refers to creation of the mind, invention, literary and artistic works and symbols, names and images used in commerce. Now, coming to forms of IPR, basically, if you see IPR, there are two forms of IPR exist. One is commercial, which refers to basically the monetary benefit of the person who has evolved on or who has created a kind of product or services or who owns it. Okay, so normally it is referred in business circles. There is another form which is non-commercial, and mostly it is in literary world and academic world it is used, where one gives credit to the work he has used by somebody. Okay, say for example, if I have written an article, and then tomorrow if you are using my article to write another article, okay, then you whenever you are writing your article, you refer my article and myself in your article. Okay, this is a kind of giving the credit to the person whose work one has used in his own work. Okay, now coming to history of intellectual property rights, well, history goes into 14th century in Europe. The first copyright was given to a book uh, in the city of Venice. Okay, that time it was called as Republic of Venice. Now it is very much part of Italy, but those days it was Republic of Venice. Okay, and they had a practice of giving some kind of copyright to the books they have published. Okay, and it was continued 14th century onwards uh, in Venice. In Europe, especially in England, it was Statute of Anne in 1710, which was the first copyright act which was published, and thereafter it was followed. In India, the Patent Act was used some 150 years ago. That is around 1856 Act. It is called 1856 Act, and which was based on British patent system. There are two important treaties which forms the part of protection of intellectual property right. The first one is Paris Convention for protection of industrial property, dated 1883. Then another one was Berne Convention for protection of literary and artistic work, dated 1886. Both treaties are administered by WIPO, okay, which has headquarters at Geneva, Switzerland. Well, when we talk about need of IPR, okay, it is very much needed for the person who has created, because he must get certain kind of credit or he must get some kind of benefit. Okay, to promote, the first one is to promote creation and innovation in the areas of technology and culture for a better life. Okay, so normally what happens is if somebody discovers something new or some innovative idea, okay, it is basically for a better life for the person himself, better life for the society. Okay, uh, the second one is protect and encourage legal rights for creators or innovators. So say for example, if you have discovered something new, okay, intellectual property rights gives you a kind of privilege to protect your interest, okay, commercial as well as non-commercial, okay, through credits, uh, so that whenever your work is being used, you are referred. Okay. The third one is promote and catalyst for the economic growth. Well, it is a kind of, rolling the economic cycle when we talk about implementing intellectual property rights. Say, for example, if you have come out with a kind of a patent, then what happens? If somebody uses your patent, you get the royalty. Okay, and when you get the royalty, you get certain kind of money, and with that money, you are encouraged to do more work, and a kind of economic cycle is on, because once money is involved, there is movement of finance. Okay, so it rolls your economic cycle in your society. Okay, sets a balance between innovator and user. Yes, definitely. What happens is, say, for example, if you have innovated something new, and people start using it left and right without giving you credit based on your product, they come out with new product and they go on propagating it, and finally you don't get a benefit. Or otherwise, what happens? You come out with a product and you keep to yourself, okay? Because you are scared that others, if they use it, they won't give you the credit or any kind of benefit. So what happens? The laws basically draw a kind of balance about between the innovator and the user. The user has certain rights to use, which is decided by the innovator in terms of monetary benefit, in terms of getting the credit. Okay, so ultimately, this whole thing about intellectual property right is about the improvement of quality of life. Well, coming to categories of IPR, there are two categories of IPR. First is industrial property, in which we normally talk about patents, trademarks, industrial design, and geographical indications. And the second category with which we as a librarian we are more concerned with, uh, that is called as copyright, in which literary works, drawings, designs, sculptures, performances, etc. do come. Well, coming first to the one industrial properties, the first one is patent. Okay, uh, patents are basically these are exclusive rights to the innovator. Okay, who has invented or discovered something new. Okay, uh, with respect to the designs, procedures, and technologies. And patent is normally awarded for 20 years. Okay, and when you have to file a patent can be filed in your own country, and the jurisdiction is only to your own country. Okay, but say if you want to have a patent at the global level, then you have to file the patent to WIPO PCT, that is Patent Cooperation Treaty. Okay, and which protects your patent rights in almost 153 countries across the globe. In India, if you want to file the patent, it is under Ministry of Commerce and Industry. Okay, Office of Controller General of Patents, Designs, Trademarks. Well, there are three types of patents. uh, when There are three types of patents. If you see, uh, first one is utility patent. Okay, where basically any innovations or discovery if you do uh, related to a new process, machine, article of manufacture, or composition of matter, or any new and useful improvement you do. Okay, so this is basically a kind of utility patent. But say for example, if you do some kind of ornamental design changes which is original and which is innovative, okay, it falls under design patents. But in biological circles, if you come out with a kind of new kind of species or plants, okay, uh, where you use asexual reproduction system, okay, and you come out with a new kind of plant or species, it falls under plant patent. Well, there are certain rights under when you register for a patent, okay, which states that no one can use the patent information for any kind of commercial purpose, including its usage, sale, or distribution. That means no one can use your patent, he can sell your patent or the patent information, or he can distribute without the patentee's consent, okay, for commercial purpose. uh, any kind of content, any kind of usage has to have means has to has the consent of the patentee. Okay, and the usage conditions, terms and conditions are normally defined by the patentee. The patentee defines in what terms, under what terms and conditions the patent can be used. The patentee can design the license of use or the conditions, or he can award the permission of use of patent, and this can be done for monetary benefit. So ultimately what happens is patentee can sell his patent or he can transfer his patent to a new owner. Okay, in that case the new owner owns the patent. Okay, The patent rights are protected under court of law in the countries, but yes, one can always challenge a patent in the court of law. Okay, if he feels that it is a kind of infringement or copy. Okay, and if it is proved, okay, the patent can be withdrawn. After the lifetime of patent, that is 20 years, the patent goes in public domain, and the owner loses all his exclusive rights. So only for the period of 20 years, the owner can enjoy all the benefits of his patents. Now, what really one can patent? Okay, any novel innovation, okay, uh, which you feel which has a practical application, okay, that can be patented. The patent can be filed within your own country or through YPOPCT. When you are filing the patent, you have to have a kind of application which should clearly state your patent title. Apart from that, you have to discuss all kind of technicalities of your patent, including drawings, etc. And side by side, you have to give all kind of prior art. They call it prior art. Any knowledge which is required to use the patent. Okay, previous knowledge. Okay, that is known as prior art. And then the inventive steps. Okay, all kind of further technicalities related to your patent is discussed under inventive steps. So there are two terms involved. One is prior art and the second one is inventive steps. Prior art is basically the prior knowledge you require to use the patent, and inventive step is the further technicalities related to your patent. The applicant is required to pay a registration fee when he is going for registering a patent. For just for my interest, when I was looking various patents, I could find the quadcopter drones. Okay, the first it was registered as patent in 1962. However, we are seeing the usage of drone nowadays a lot for various purposes. But it was patented in 1962. Another important patent which we are using is the Bluetooth technology, which was patented in July 2003. The next important concept in intellectual property rights, especially in industrial rights, is trademark. Okay. Normally we have seen a lot of trademarks. These are basically registered symbols, signs, characters, or holograms, or sometimes even colors they use. Okay, to register their trademarks. There are some non-traditional marks also. We call as sound marks or smell marks. Okay, for identification of some kind of business houses or person or groups. Okay, basically these are used in branding or marketing in order to prove the authenticity. Okay, so these are basically kind of signature symbol which are protected through the court of law. Well, if you want to register trademark in India, again, it is Ministry of Commerce and Industry where you can register your trademark. Or if you want to register your trademark globally, it is WIPO under Madrid Protocol, okay, which can protect your trademark in 122 countries. Well, these are some trademarks used by the doctors, Red Cross Society, Google, Twitter, Windows, Facebook. On day-to-day activities, we come across these trademarks. Well, there are some interesting sound marks up there. Okay, like Intel's Bong. Okay, Intel Inside Bong, 20th Century Fox. Okay, the MGM roll, I can show you the MGM roll in YouTube. uh, now you see, yeah, this roll, if you see, it is basically a sound mark, a registered sound mark. In India, first registered sound mark was Yahoo jingle. Okay. Besides, there are many sound marks nowadays registered by the government of India as well as at global level. Okay. Uh, Often we have seen two kinds of symbols. One is TM, okay, trademark, and then sometimes we have seen an R within a circle. Okay, when we say TM, it is trademark. Okay, and when it is R, it is registered trademark. Okay, a registered trademark is basically once you have a registration certificate for your trademark. Okay, but the moment you file for a trademark, you can use TM symbol, trademark symbol, but you cannot use the R symbol. Okay, R symbol only you can use once you have a registered trademark. Okay, so anyone can use trademark once he has filed. Okay, means TM symbol anyone can use, but registered trademark only can be used after the registration of the trademark. Another important intellectual property right concept is industrial design, basically which talks about aesthetic aspects, okay, or outward appearance of the services or the objects. Okay, so normally it is the two-dimensional or three-dimensional shape, size, pattern, lines, compositions, colors we use to design the object. Okay, so any kind of novelness or innovation is there in your design aspect. Okay, you can register under industrial design. Okay, uh, there should not be any kind of technicalities related to the internal design of the object or services. Those kind of technicalities go under patent. Okay, this is only the appearance or aesthetic aspects of the objects. Okay, so the relevant aspect which needs to be looked into is the shape, configuration, surface pattern of the object, the color or the line or the combination of all these together. Okay, so ultimately it gives a kind of aesthetic impression on the one who is looking to it or using it. Okay, and any kind of industrial design provides a kind of a monopoly of 10 years, which can be further extended to 5 years. Industrial design is mostly used in artifacts, handicraft, packaging, ornament, cloth design, houseware, designing electrical appliances, okay, uh, leisure goods, vehicle appearance designs, and so on. Coming to need of industrial design, uh, these are basically statutory rights to protect the interest of designers, okay, the one who has designed the product, uh, in order to give best return on the investment. Say, for example, if you are designing a product, you are investing something on it. So, your registration of industrial design or the thing, it gives you a kind of investment, whatever investment you have done in order to create the product. Okay, and it creates a kind of competitive environment for better design. Okay, say for example, if you have designed a product, okay, and same design is being used by the others, there won't be much improvement. Okay, but if there is a kind of monopoly, the others are definitely compelled to come out with something which is better than your product. Okay, so it gives a kind of competitive environment, and it offers better product designs for the customer. So ultimately the customer gets benefited. Okay, uh, it prevents all others from producing, importing, selling, or distributing products having an identical appearance. Okay, uh, the product you have prepared. In India, we have the Design Act, the Designs Act 2000. This act is to consolidate and amend the law relating to protection of designs. Uh, it makes efficient and user-friendly legal system for protection of design in India. It promotes creativity and protection, and it is compliant to TRIP. Okay, TRIP, which is trade-related aspect of intellectual property rights agreement. It is a global agreement uh, to which this act is compliant. Now coming what you can register under industrial design. Okay, uh, any finished article which appeals to, okay, uh, or which can be judged something new by eye. Okay, which is new and original, and previously it is not being made or published. Okay, significantly distinguishable from other designs or combination of known design. So if there are products, okay, okay, it is basically different from the previous products. Okay, uh, finally, whatever you are going to register, okay, it should not have any kind of technical impact on the function of the product. It is purely and purely aesthetics of the product.